Student text number 2. The vignette on this tape is of a client-attorney interview conducted prior to a scheduled court appearance. A deaf man has been charged with driving while intoxicated, driving while license is suspended, and driving a motor vehicle with an expired tag. He is a repeated offender, and this current charge is a violation of his probation requirements. The attorney, a female who has been court-appointed to represent the deaf defendant, will interview her client to get the details of the incident and to prepare him for what will happen during the scheduled court appearance. The speakers will now provide you with their introductory comments.
My name is Jean Lawson. I'm a lawyer practicing here in Charlotte, North Carolina, and for the past 15 years my practice has been basically in criminal law. I represent people who are charged with traffic offenses and other criminal offenses. Sometimes I do it as a private attorney, and other times I represent people who are unable to pay the full cost of an attorney. Today I'm representing Mr. Philip Wells, who has been assigned to me through the court system. I represent him as a public defender. He's charged with a second offense, driving while impaired, and driving while his license is revoked. These are serious offenses in North Carolina and could carry prison terms, so it's very important that we discuss his cases thoroughly. Mr. Wells, these warrants show that you were arrested for driving while impaired and also for driving while your license is revoked. And I want to hear what happened, but before that, can you tell me a little bit about yourself and your background, please? Did you graduate? Okay. And do you have any education beyond that? Okay. What kind of work do you do? How long have you been there? Do you have any good friends or supervisors who might be willing to come to court and speak up for you if it came to that? Okay. Do you know his last name? Okay. Does he know about the trouble you're in? Okay. Would it cause a problem if you told him about the fact that you got these charges and had previously had a DUI? Good, good. Well, tell me about your family. How old is he? Does he live with you? Okay. And do you support him? I'm sorry to ask you all these personal questions, but I never know when I might find something that will help. Okay. Now, you're currently married to your second wife, is that right? And how long have you been married to her? Does she know about this charge? How is she reacting to the fact that you were charged with this offense? Okay. Is she upset? Okay. Is she upset because you're in trouble, or is she concerned about the drinking, or both? Okay. Um, how long have you, well, how long have you been drinking heavily enough to get in this kind of trouble? Okay. So that would be since you were about 31, is that right? Right, that's what the warrant says. But why don't you tell me what happened on this evening? Um, the offense we're talking about is the one that you have to go to court on next month, this second offense. And then we'll go back and talk about the first offense. Well, that's what I want to do, is to try to help you to figure out a way, first of all, if we can, to get you out of this. And if we can't get you out of it, if we can't avoid a conviction on the charges, then to minimize the impact on you. And I can tell you now that one of the ways to do that is going to be to get treatment for your alcohol problems and for any other problems that led to your drinking and to your continuing to drink. And it would be my goal to try to make sure that you don't get some kind of long sentence of imprisonment. Have you ever been convicted of anything else? Well, it depends on how good you are about going into treatment. If you go into it with sincerity, then the people who are doing the treatment will come to court and say, Philip Wells came to us and he's working on his problem and we think he's a good risk to be out on the streets. And the whole object is to convince a judge that you shouldn't be locked up and that you're not a danger to the community. That's the only reason that a judge would put you in jail, is if you're a danger to the community or if you continue doing what you have been. So if the facts that you tell me about lead me to conclude that you're either going to get convicted or have to plead guilty to driving while impaired, then I'm going to recommend that you do everything you can to convince a judge that you shouldn't be locked up. And there's some things you can do, like going into treatment. Unfortunately, some people go into treatment and they just do it so that they can keep driving or for reasons other than sincerely trying to work on their alcohol problem, and that generally gets reported back to the judge, and it will hurt you rather than help you. Okay, so what we need to do first is talk about what happened that night, because one of the first issues is whether the police officer had probable cause to stop you. Police can't just stop somebody, anybody driving down the street, and get them out of their car and smell their breath. They have to see something that gives them probable cause to believe that something illegal has happened. Tell me about what you drank that night and what you heard the policeman say and what you think you did that gave him cause to stop you. Did he tell you why he stopped you? Did the policeman tell you that you were weaving when you first met him and had a chance to talk to him? Or did he tell it to you later down at the law enforcement center? Okay. Did you feel like you had been weaving or driving improperly? Okay. Did the officer give you any field sobriety tests, the ones where he makes you touch your nose and walk in a straight line? Did he tell you how he thought you did on that test? Did you sense that you did well or poorly on the test? Did anybody at any time give you any of the other tests, like walking a straight line or walking toe-to-toe or touching your nose? Okay. Uh, did you notice whether any other police officers pulled up out there when the first officer stopped you? When did you first learn that he knew you didn't have a driver's license? Okay. Where had you been drinking that night, and do you remember what you had to drink? Okay. And when did you get there? Do you remember? Okay. And when did you leave? Right before this happened? Okay. Tell me what you drank, if you remember. Do you remember
No.
what you were drinking? Is there a particular thing that you normally drink when you drink? Okay. Um, but you have no idea how much you had that night? Okay. Were there other people there with you drinking who might be able to tell us how much you'd had? What's his name? Gary, so that's two people. Okay. Um, when you got down to the law enforcement center, what happened? Okay. Do you have any idea how much time elapsed between when you arrived at the law enforcement center and when you took the breathalyzer? Okay. The police report shows that uh, you blew .19 twice within 5 minutes of each other, and that's within an hour after your arrest. So it looks like your blood alcohol content was probably higher than .19 at the time you were stopped. Did the police tell you prior to the arrival of the interpreter that you were entitled to have a neutral, independent witness for the breathalyzer test? Okay. Do you know whether the interpreter worked for the police or was an independent interpreter? Okay. And did the interpreter tell you that you were entitled to an independent witness or a member of your family to come down and see the test? Okay. Well, that may be something we can work with. Because there are some requirements about informing you of which witnesses can be present if they can get to the breathalyzer room quickly enough to witness the breathalyzer test. We may have some trouble because they had to put you in a holding cell for a while, but it would be worth looking at whatever records they have down at the jail and talking to any deputies who saw what happened, and we may be able to use that to block admission of the breathalyzer result. I don't know. There are two problems. First, you can be convicted of driving while impaired without the results of the breathalyzer if the judge believes beyond a reasonable doubt that you were impaired based on the testimony of people who saw you. And it may be enough if the police officer testifies that he saw you driving erratically, and that you were fumbling, and you had a strong odor of alcohol about you, and any other observations he made of you either out on the road or down at the law enforcement center. So that even if we're able to keep the breathalyzer reading out of evidence, you still could be convicted. So one of the things that would be helpful to do is talk to the police officer and find out what he's going to say. And I'll do a little research on that before we make any decisions. But it's possible that we can at least keep the breathalyzer out. And of course, with your prior conviction, that would be worth it. The other part of that is that if we're able to convince the district attorney that he's not on firm ground with this case because the breathalyzer may not be admissible, the district attorney may offer to let you plead guilty to some lesser offense. Do you have any questions about that? Do you think that your friend